Hello. The question that we got revolves around a direct comparison and contrast to the English and Malaysian approach of contract law when it comes to undue influence as a vitiating element. Vitiating element, what does that possibly mean? Let's just say that in layman terms, it is simply a factor that can cripple or invalidate a contract. Now, undue influence. It is an equitable doctrine that is applied in instances not covered by common law juris. Undue influence has the capability of rendering a contract voidable at the innocent party's option. In other ways, the parties can choose to 1. Affirm, 2. Rescind the contract, or 3. Use undue influence as defense. It is fair to say that influence in the broadest sense is acceptable and somehow of normalcy. People on the daily influences, especially those of proximity to us. Is that a bad thing? Not really. It only becomes problematic and subjective to scrutiny when that influence is exploited. To go about this question, we will break it down into two parts. Ammar will address actual undue influence under English law, while Damian will tackle presumed undue influence, clause 2A and 2B. As for Malaysian law, Melven and Waleed will follow in the same flow.
In this part, Damian and I will be evaluating undue influence in English law. Undue influence occurs when one person's choice to act independently is overpowered by another's, resulting in a decision that is not his own. Undue influence was described by Lord Justice Lindley in Alcard v. Skinner as some unfair and improper conduct, some coercion from outside, some overreaching, some form of cheating, and generally not always, some personal advantage gained. In the case of Barclays Bank PLC v. O'Brien, Lord Brown Wilkinson approved the classification of types of undue influence proposed by the Court of Appeal. In the Bank of Credit and Commerce International v. Aboudi, in terms of distinction between actual undue influence class 1, which I will further elaborate on, and presumed undue influence, which is further subdivided into class 2A and class 2B cases, which my groupmate Damian will further discuss on later. The word actual is considered to be specific overt acts of persuasion or overt acts of persuasive conduct, which result in the persuaded party making a decision which was not of their own volition or for their benefit. Actual undue influence cases are comparable to the pressure required to establish duress. Lord Nicholas characterized this undesirable behavior as overt acts of improper pressure or coercion, such as unlawful threats. In Royal Bank of Scotland PLC v. Etheridge, added that today there is substantial overlap with the principle of duress, as this principle has subsequently developed. How do we prove actual undue influence? To prove actual undue influence in English law, the victim must show that the offender had the ability to influence the victim. The influence was used and that the use of was undue. There's no requirement that there be a prior history of such authority. It can be used for the first time in connection with disputed transaction. The claimant bears the burden of proof in demonstrating that the stronger party used undue influence over the weaker party, and that the latter was unable to make a free choice when entering the agreement. It has been stated that in order to prove true undue influence, it is necessary to demonstrate that the transaction in question is clearly to the innocent parties determined. In CIBC Mortgages Ltd v. Pitt, the House of Lords overturned this criteria, holding that in an instance of the actual undue influence, the victim does not need to prove that the transaction was manifestly disadvantaged. According to Lord Brown Wilkinson, a person who has practiced fraud cannot argue that it should be ignored because their victim benefited as a result of it. In the case of William v. Bailey, concerning the mortgage over a colliery that has been executed by the claimant following threats to prosecute the claimant's son of forgery, it was held that the agreement was found to be voidable due to the bank's actual undue influence over the claimant by threatening to prosecute the son. Daniel v. Drew was a recent case that focused on the conditions of actual undue influence that led to an elderly aunt being pushed to retire as a trustee by her nephew. The case emphasized Etheridge's previous points in a clearer and more forceful manner. The Court of Appeal concurred with the judge in the first instance and found actual undue influence It concluded that the aunt had been driven by the nephew's actions instead of being led by her own free choice. To summarize, in these circumstances of actual undue influence, the complainant is not required to prove any form of special relationship or that the transaction resulted in a visible disadvantage. On the other hand, complainants face a difficult burden in demonstrating that their free will to accept or decline a certain contract was influenced in any way. What about in the case of actual undue influence exerted by a third party? In the case of actual undue influence exerted by a third party, where one party seeks to avoid a contract on the grounds of undue influence by a third person, it must appear either that the third person was acting as the other party's agent or that the other party had actual or constructive notice of the undue influence. In most cases, undue influence exerted by a third party is used by husband and wife. When a wife establishes undue influence, she is entitled to have the transaction set aside in her husband's favor. However, the transaction is usually with a bank that was not a party to the influence. Following the judgment in National Westminster Bank PLC v. Morgan, it became evident that banks were not acting in a credible position that would give rise to an undue influence presumption. Another factor required to be present in order for contract to be set aside, as opposed to the bank, the case of Barclays Bank v. O'Brien established the idea of constructive notice. This is when a bank is investigated and it fails to take reasonable precautions to guarantee that the transaction was entered freely and without undue influence. Constructive notice is then issued. Thank you.
Hi, I am Damian, and I will be presenting on presumed undue influence under English law. Presumed undue influence can be divided into two classes, namely Class 2A and Class 2B. There are three stages in proving Class 2 undue influence. Stage 1 for Class A is that an innocent party must prove a pre-existing relationship of a special kind between parties. Class 2B, on the other hand, is when an innocent party must prove a Class 2B, on the other hand, is when an innocent party must prove a pre-existing relationship of trust and confidence between parties. Stage 2 and 3 are similar for both classes. In Stage 2, there has to be something about the transaction that calls for explanation by the dominant party. The court will have to examine the nature of the transaction sought to be avoided and decide whether an explanation is needed. If yes, there arises a rebuttable presumption of presumed undue influence. For Stage 3, the burden shifts to the dominant party to provide explanation in order to rebut presumption of undue influence. Court must consider whether the presumption of undue influence is rebutted or the transaction is avoidable. If not, as a matter of law, some relationships give rise to the presumption of undue influence. Parent-kid, solicitor-client, doctor and patient, trustee and beneficiary, and religious advisor and disciple are the connections where undue influence is inferred. Within Class 2A, the connection of a husband and wife does not generate a presumption of undue influence. The regulation does not apply between an employer and an employee. This can be seen in the case of Royal Bank of Scotland plc and Petrich, where there were 8 joint appeals in which husbands of homeowners secured loans for their own respective businesses while using their wives' houses as mortgages, although they had no direct benefit from it. Unfortunately, their business did not succeed and the bank sought to take possession of their homes. The issue that arises is whether the wives declared the agreement with the bank void and keep their houses even when they had been unduly influenced by their husbands to enter into an agreement. The House of Lords stated that the clients receiving legal advice has to be an obligation by the bank, especially for couples where the transaction of security of home for a loan that would only benefit one of them. For example, getting a solicitor to speak with the wife and husband in private individually to discuss the loan and receive their fully informed consent. Therefore, the security of the bank is protected by the expression of free will when the said solicitor certifies the free consent. Once legal advice is provided and free consent is given, the bank is able to possess the matrimonial home as the agreement will stand. The next agenda that I will be presenting is on rebutting the presumption of undue influence. If a person benefiting from the transaction can establish that the transaction was the free exercise of independent will of the party who was unfairly influenced, the assumption is rebutted. In the case of Smith and Cooper 2010, Ms. Cooper purchased a bungalow for £84,000. She entered into a relationship with Mr. Smith and later added Mr. Smith to the title for the bungalow as a joint tenant. At the same time, the couple bought an adjacent plot of land for £9,000. At a later date, they bought a cottage for £115,000. They paid for this using the £15,000 of Mr. Smith's money and the mortgage secured on the bungalow. Mr. Smith and Mrs. Cooper later broke up. Ms. Cooper sought to have the declaration of joint tenancy on the bungalow set aside for undue influence. She argued that Mr. Smith had a position of ascendancy over her as he dealt with all her financial matters in the relationship. Meanwhile, the transaction was not readily explicable. In light of this, Ms. Cooper argued that Mr. Smith's beneficial interest in the cottage was quite small. Mr. Smith responded that Ms. Cooper had been properly advised by a solicitor, so she entered into the transaction freely. The solicitor acted jointly for the couple. The court held that Ms. Cooper had a relationship of trust and confidence with Mr. Smith. The bungalow transaction was not readily applicable, which raised the presumption of undue influence. The solicitor's advice was inadequate to rebut the presumption of undue influence. The solicitor failed to consider that there may be a conflict of interest in acting of both clients. He was also not aware of the underlying circumstances affecting Ms. Cooper, and it did not occur to him that she needed greater protection. His advice was therefore not capable of freeing her from the undue influence. However, the transfer of the bungalow and the purchase of the adjacent land was effectively part of the same transaction. This meant that it would not be fair to split the land 50-50. The court therefore awarded Mr. Smith the full value of the adjacent land as a condition of setting aside the bungalow transaction. Since Ms. Cooper solely owned the bungalow used to acquire the mortgage, her contribution to the purchase of the cottage was far greater than Mr. Cooper had made. The court declared that he owned only 26% of the beneficial interest in the cottage. Lastly, I will be talking on the remedies of undue influence under English law. Due to the equitable notion of undue influence, equitable remedies may be awarded. The standard equitable remedies are accessible, but they are not subject to the same general limitations as other remedies. The most common remedy for excessive influence is the suspension of the relevant action. The courts will order restitution for the benefits received, and a claim for profits resulting from this may be filed against the person who profited. Frequently, returning parties to their former places will be impossible. In this scenario, the courts will restore the status quo by doing what is practical and just among them.
With my friends having established the approach for the English law of contract towards undue influence as a vitiating factor, I will now go towards the Malaysian law approach to establish the differences between the two. Well, since undue influence has already been explained by my friends, I'll just jump straight to the topic. As we understand at this point, undue influence deals primarily with consent, and consent in Malaysia is defined under Section 13 of the Contracts Act 1950. It is simply two or more people who are said to consent when they agree upon the same thing in the same sense. Section 10, subsection 1 of the Contract Act 1950 requires consent to be free to allow the creation of a contract. Thus, it creates the whole argument of undue influence. Now, undue influence comes as a factor in the absence of free consent. At least, that's how it's considered in Malaysian law under Section 14b of the same Act. To further clarify, it is to be understood that undue influence cases consist of an existing agreement between both parties, as they have both agreed to the same thing in the same sense. However, this is where things get complicated. If there was undue influence, the consent was surely not free, right? And Section 10, subsection 1, requires consent to be free for the forming of a consent. This is where Section 20 of the Contracts Act comes into play. It states that where undue influence was discovered, the agreement becomes a voidable contract at the option of the one coerced into the agreement. Alternatively, the contract may also be set aside absolutely. It may also be that if the party entitled to avoid the contract has received any benefit, the court may set the contract aside upon such terms and conditions as the court may seem just. Hence, this is how undue influence is remediated for in Malaysia. Hey, we've been talking so much about undue influence, but what is it exactly under Malaysian law? Well, Section 16 of the Contracts Act might answer that for us. I quote, "A contract is said to be induced by undue influence where the relations subsidizing between the two parties are such that one party is in a position to dominate the will of the other and uses the position to obtain an unfair advantage over the other." It is to be noticed that at this stage, English law and Malaysian law are quite parallel upon that where undue influence has been proven, it is the influencer who is burdened to show that the contract was not induced under undue influence. However, this is also where the differences under English law and Malaysian law are perceived. English law distinguishes between actual and presumed undue influence. In Malaysia, Section 16 is not entirely clear. It works on the basis of relationships subsisting between the parties, which is not actually a factor under actual undue influence in English law. Well, Malaysian law haven't really focused on this aspect, to be honest. They do usually interpret Section 16 in alignment with English law. Some cases to refer to are Pusatore and Kanapa Chetio, Tengku Abdullah and Mohammed Latif, and HSBC versus Site United Young Enterprise and another. One more difference between English and Malaysian law is that in Malaysia, in all cases of undue influence, the victim must show that the influencer received an undue advantage. In English law, this does not apply to cases of actual undue influence. In Section 16, subsection 2, a person is deemed to be in a position to dominate the will of another, where he holds a real or apparent authority over the other, or where he stands in a fiduciary relation to the other, or where he makes a contract with a person whose mental capacity is temporarily or permanently affected by reason of age, illness, mental or bodily distress. This is how influence is presumed. Notable cases are Rosli bin Daras and Mansoor Harun bin Sad, HC and Ko Cheng Bok and Chok Cheng Pun. Let us now talk about fiduciary relationships arising from Bristol and West Building Society and Matthew, Chapter 1. It is basically someone who has undertaken to act for the benefit or welfare of another in a particular matter in circumstances which give rise to a relationship of trust and confidence. The distinguishing obligation of the fiduciary is the obligation of loyalty. Some examples can be parents and children, solicitor and client, and trustee and beneficiary. While the approach of this aspect is mainly similar to English law, its existence is worth noting and highlighting for cases such as Dara Rajatnaram and Taduk Jadingar Singh, and Tengku Abdullah and Mohammed Latif. Thank you.
All right. So now that Melven has explained Malaysian law's position when it comes to undue influence, I will delve deeper into the fine linings of the topic at hand. Analogous to English common law, in Malaysian contract law, according to Section 16 of the Contracts Act 1950, the onus of proof lies upon the party setting up undue influence, or in other words, the probable victim. The person is required to prove three things in order to be able to shift the burden of proof onto the influencer. Firstly, according to Section 16, sub 1 that the other party was in a position to dominate his or her will. Secondly, that the dominant party used their position to obtain an unfair advantage over the innocent party. The third, according to section 16, sub 3, sub A, that the transaction was unconscionable on the face of it or through evidence. We see a brief description of burden of proof in the case of Raghunath Prasad and Saraju Prasad, in which a money lending transaction appeared to be unconscionable because of the high interest rate charged, and hence the borrower wanted to set it aside on the grounds of undue influence. It was held that the relationship of the parties must be looked at before the unconscionableness of the bargain. And due to there being no special relationship between the parties, it was determined that there was no undue influence, even though the interest rate being charged was unconscionable. Once the innocent party manages to prove the previously mentioned requirements, undue influence is rebuttably proven. The burden of proof then shifts to the dominant party accused of unduly influencing, to prove that they did not coerce the party claiming to be innocent into a contract. The concept of rebutting presumed influence in Malaysian law is much the same as English law. A demonstration is seen in the 1929 case of Inshe Naria and Sheikh Ali B. Umar, where an elderly illiterate woman gave all her landed property as a deed gift to her nephew. Later, she sought to set it aside based on grounds of undue influence. To rebut the presumption, the nephew claimed that she received independent legal advice from a solicitor. But based on evidence, it was later revealed that the solicitor received all instructions from the nephew himself. It was held that the presumption of undue influence arose due to the relationship the two parties shared. However, the nephew failed to rebut the presumption. The final aspect to take a look at now is undue influence being exerted by a third party. Malaysian case law applies principles of English common law in this situation. We observe this in the case of Southern Bank Berhad and Abdul Rauf bin Rakinan, where a bank sued a couple, the husband as the first defendant and the wife as the guarantor. The wife admitted to signing the guarantee, but claimed she was unduly influenced in doing so by her husband. The bank initially applied for a summary judgment against the wife, which the Sessions Court dismissed, so the bank went ahead and appealed to the High Court. It was held that there was no presumption of undue influence between the husband and the wife. However, where a wife has been induced into standing as surety for her husband's debt, she has an equity against him to set aside the transaction. Her right to set aside the transaction will be enforceable against third parties as well.
Let me break it down to you now. In both Malaysian law and English law, undue influence occurs when one party is found to abuse his authority on the other party to enter an agreement overpowering the victim's own volition. However, as you can see in the grid, while English law distinguishes clearly and has a set of criteria for actual undue influence and presumed undue influence, it's quite a blur for Malaysian law. Next, in Malaysia, all cases of undue influence come with the onus to prove that the victim was at the end of some sort of caution. In cases of actual undue influence, under English law, there is no need to prove such a thing. So, albeit the doctrine of undue influence is based upon the same foundation in both sets of laws, some criteria may differ, but it cannot be denied that this dogma is considered as a vitiating factor in contract law. It has the power to affirm or rescind a contract, or like mentioned before, be used as a defense. Thank you for your kind attention.